Yes. Okay, we are gonna go back to our actual screen. Sorry, guys, for that dizzy moment. All right. Here we are, okay. And then we'll have Carrie Ketchum from Utah Dispute Resolution, talking about conflict resolution, have a break. And then Southwest Behavioral Health, Jessica and Amanda will be presenting on assisting victims in crisis and those facing also dealing with substance abuse. And then we will break for lunch. Lunch is on your own. 1 o'clock we'll do a breakout, and then 2:45, our presenters will be virtual, but we'll be hearing from Hope from Recovery, and then we'll end the day with Beatrice and I talking about best practices and collaboration and learn how. So it should be a good agenda. We will try to keep an eye on the chat as well, but if you guys have questions, please raise your hand here or ask the presenters. They all said they like questions, and then we wanted to do a little, everyone kind of get our brains going for a minute. Oh, this isn't the one. There we go. So, in the room, you guys can turn to your neighbor. I'm gonna mute the room, and ask this question. If you had to describe how you're feeling right now as a weather pattern, what's your forecast? And then for those on our online audience, you guys can put it in the chat. All right. I love hearing all of your guys's weather. We had some good ones in the chat. You guys are seeing those. Can you guys hear us okay now online if I'm not using a microphone? Yeah. And your mic is off. Okay. I know it's off. I'm asking the audience online, sorry if they can hear me. Okay, that's a mic. Okay. We're gonna try without the mic because it's obnoxious to Apple mics, but you might need it still. Okay. All righty. I'm just gonna use the mic. Okay. Perfect. Thanks, everyone. I'm glad you guys could share that. We have some great ones in the chat as well. Just for those in the room, if you need Wi-Fi, the connection is conference, and then it's Abby, ABBEYINN, Abby in, all lowercase for the password if you need Wi-Fi. And then there is also in the back for those that are in the room, there are some coloring sheets, some markers, coloring stuff if you need that to help concentrate. I'm a person that needs that. And then we do have handouts in the back as well that will be part of our presentation at the end. And then that, yeah, we are gonna get started. So we are super excited to turn the time over to McKinley. Let me get your presentation back up. Let's make sure I'm on the right slide. Oh goodness, where did yours go? Sorry, I had it. Where did you go? Too many tabs. Sorry, guys. Let's see.
I think it's you're right here on assisted. So keep going.
Right there.
The one more.
Oh,
No,
one
one
more.
more.
There we go. Okay, sorry, thank you. I couldn't remember what it was in. Okay, I'll turn the time over to you. I'm gonna, I think that might just helps drown out outside noise, but you can hold.
Okay. Okay.
And then there's your clicker.
Okay.
I'll let you introduce yourself.
I'm gonna, if I talk without the mic, can everyone hear me? What about online too? No.
Yeah, you're good.
I'm gonna try it without, and if anyone has issues hearing me, please let me know. So I'm McKinley Silvers. I am the managing attorney for the domestic task force at Utah Legal Services. So at Utah Legal Services, I'm sure a lot of you have heard of us, or hopefully refer your clients to us as well. But we, in addition to doing protective orders and custody and divorce, we also do housing, like evictions and consumer, which is like collections, and then public benefits. So we do a lot at Utah Legal Services. So if you have a client who has multiple things going on, please feel free to refer them to us. And if nothing else, we can at least help them find resources. So let's see if I can work this quicker. You want me to just bring it? No, oh, I probably point it this way. No. Do you know how it works? Not necessarily. Oh, it looks like it's off. Oh. Maybe got his batteries. Let me get you some batteries because these looks like they're not working. Okay, just stay off. Or maybe. How do I go to the next page? Space bar. Yeah, it's space bar I thought, but it's not doing it. Oh, it's not? Oh, no. Oh. I hit the clicker instead. Okay. So we're gonna be talking about custody. What is custody? Types of custody arrangements, how to obtain a custody order, and then how custody is determined and the role of evidence in getting a custody order, and then empowering the survivor. And through that, I'll be talking about how all of you as advocates can help the client through that process. So just to start off with, I know it's early. I know we're all trying to wake up. So I would love some input just to get us all excited and paying attention. So when you hear the word custody, what do you think of? What is custody? There are no wrong answers. Feel free to just,
Like who physically has the children, like taking care of them, or has not control, but like in charge of them at that moment.
yeah. Yeah. Okay,
Possession.
sorry, say that louder.
Possession of someone or something.
Possession of something, yeah. What were you gonna say?
Somebody, one of the parents that gets to make the decisions, medical, whatever decisions.
Right, gets to make the decisions, has possession of the children, has control or, yeah. Anything else you think of when you think of custody?
Responsibility.
Yeah, great one, responsibility. Anything else? Also, I'm not checking the online people. Is there a way to know if they're commenting?
Yes, Lisa said taking ownership. Edith Cruz said protective care of a minor, and then Abby from Haven said parents' rights to raise child or children day to day and make decisions regarding their needs.
Great. So those are all correct. There's a lot that custody involves. And so when somebody comes to you and says, I want custody of my children, there's a lot of questions that go into what do you mean by that? You know, what exactly is it that you are looking for? So generally, it's broken down into three things: legal custody, physical custody, and then parent time. So legal custody is what you were talking about, who has the right to make those important decisions in the child's life. Especially regarding education, healthcare, and religious upbringing. Physical custody refers to who has possession of the children or where they live. And which parent's house will be used as the primary home for things like where they will go to school. And so the parent who has physical custody is usually referred to as the custodial parent, and the other parent is referred to as the non-custodial parent. And then parent time refers to the time that the non-custodial parent gets with the children. It's also often referred to as visitation, so you might hear it both ways. But it's really moving toward parent time because visitation just makes it feel like the other parent doesn't really have the kids, just gets to visit with them. Thank you. Yeah.
Can those be split between a parent, like legal custody isn't just one parent, but it's split between two and then also physical or?
Yes. So I'm gonna get into all of that and I'll give a lot more details on that. But great question, yeah. So now we're gonna talk about the types of custody arrangements, just as you were asking. So when you hear sole custody or joint custody, what do you think is the difference? Or what comes to mind? Yeah,
Either one parent has custody of the children, or both parents have joint custody of the kids.
yeah, great. Anything else that you've heard clients say or have questions on? What about, do you think you can have sole legal custody but joint physical custody or vice versa? Yeah. So I put this, are you confused yet? You are not alone. There's a lot of misconceptions in this area of the law. And so I'm hoping to help clear up some of those misconceptions. So here's some of the questions we get asked a lot. regarding sole custody versus joint custody. So I often get asked, if I have sole legal custody, does that mean the other parent loses all rights over the child? What do you guys think? Yep, you guys are right. No, it doesn't. If somebody wants to have the other parent lose all rights over the child, they would need to terminate their parental rights. And so just having sole legal custody does not allow that. If I have sole legal and sole physical custody, does that mean the other parent is not allowed any parent time? A lot of head nods saying no, you are all correct again. And we'll talk more about that in a minute. What about if the court orders joint physical custody, does that mean the parents have 50-50 parent time? No, you all are right again. You guys are very informed, so that's awesome. So with legal custody, it can be broken into sole and joint, and physical custody can be broken into sole and joint. So with sole legal custody, one parent makes the important decisions, but the custodial parent is still obligated to inform the non-custodial parent of the decisions they make and what's going on in the life of the child. With joint legal custody, both parents make those decisions. And then usually a decision-making procedure will be put in place for when the parties need to make a decision, but they can't agree. And so a lot of times that involves both parties talking about it, and then both parties needing to meet with a professional involved in the area. So if they're making a decision about education, maybe they meet with the school counselor. Or if it's about a health issue, they both need to meet with the doctor. And then if they still can't agree, then they can go to mediation. And only after that, if mediation fails, then they can take it to the court. That's the general procedure, but there's a lot of variations within that people can come up with. When it comes to physical custody, there's a lot more confusion about sole versus joint. So with sole physical custody, sorry about the bar, I'll be sending this, or we'll be sending this after, so you guys can all see this too. But with sole physical custody, the children live with one parent for more than 255 overnights per year. So the other parent basically just gets minimum parent time. And I'm not exactly sure what it says under there.
Yeah.
I can't remember. But. Let me think. Can you just up for the year? Oh, right, okay, so with sole physical custody, the non-custodial parent is still entitled to some form of parent time. That could be supervised, that could be even all they get is virtual parent time, so phone calls or Zoom calls. So there's a lot of variations in there depending on what's going on, but no matter what, they're entitled to some form of parent time unless their rights are terminated. With joint physical custody, the children live with both parents for at least 111 overnights. So it could be anything more basically than minimum parent time, it becomes joint physical custody. And so a lot of people think, you know, if I get them the majority of the time, I should still have sole physical custody, but anything more than the other parent getting minimum becomes joint physical custody, or yeah. So there can be any variation of those things. With sole legal and sole physical, the children primarily live with the custodial parent, and that same parent makes the decisions regarding the children. With sole legal and joint physical, that really does not happen. it's very rare for one parent to have sole legal, but then they have joint physical. Because if they're both spending half the time or close to that amount of time with the children, they really should both be able to make those decisions for the children. Joint legal and sole physical, the children live with the custodial parent more than 255 overnights, but both parents make decisions about the children's lives. And then finally, joint legal and joint physical, the children live with both parents for at least 111 overnights, and both parents make decisions. What do you guys think is the most common arrangement? In the majority of cases? I'm hearing a lot of joint both. Anyone else have any? Joint legal, sole physical? Yeah. What about if there is domestic violence involved? Do you think that changes that equation? What do you think then is the most common?
Joint legal and
Joint legal and sole physical? Yeah, so you guys are correct again, or you all are correct again, I should say. That the majority of cases do end up with joint legal and joint physical. But a lot of times when domestic violence is involved, it is joint legal and sole physical. Just, well, for a lot of reasons that we'll get into. Okay. So obtaining a custody order, there's a lot of different ways that a person can go about requesting custody of their children. You can do a petition for divorce or a petition for custody, and then a motion for temporary orders. Sorry, the format got changed a little bit, so it looks kind of weird, but still says the same things. You can do it through a request for protective order or request for a child protective order as well. Do you all know how many types of protective orders there are? Or what are some of the ones you all work with? Anyone? No?
The protective order for the adult and the protective order for the child, where the adult applies for the protective order on behalf of the child.
Right, so one where the adult requests the protective order, but then through that also protects the child, or just where the adult applies for one solely for the child.
So on the child protective order,
Mm-hmm.
once it's granted, I know like when they're protected under the adult,
Mm-hmm.
it's only for 150 days. Is the child protective order the same or is it longer?
It's similar. It's usually 150 days as well. Because with both, the goal is to get a more long-term custody arrangement through a divorce or custody case. It's really just considered an emergency order, and they really want it all to be dealt with in one case, whether it's the custody case or the divorce case.
So if there's domestic violence involved, is it still the same?
Mm-hmm.
Okay.
Yeah. Any other protective orders you all? Yeah, sexual violence protective order.
Alicia from Davis County said too many, and then Medium from Washington County Attorney's Office said criminal protective orders.
Right, criminal protective orders. Too. So yeah, there's the cohabitant abuse protective order. This is the one we use the most. Do you all know what a cohabitant is?
It's
Yeah.
the family, it doesn't have to be necessarily an intimate partner.
Yeah, so it can be a close family member, a married couple, or a couple living together, or a couple that has a child together but is no longer together. It can also just be roommates or it can be people that are in a consensual sexual relationship but don't actually live together. So there's a broad range of people that qualify under a cohabitant abuse protective order. And when there are children involved, this is the one I would always suggest. Dating violence protective order, like somebody mentioned, sexual violence protective order. Do you all know the difference between those two? So a dating violence protective order is for when the parties are dating, but have not yet had consensual sexual relations. Because then it would go to the cohabitant abuse protective order. So they're dating, but have not yet had sex, basically. Where sexual violence protective order is, they're not even dating, but some type of sexual violence occurs. So this could be like in a workplace setting or in a distant family relationship or something. And then there's the workplace violence protective order and civil stalking injunction. And then a child protective order, like you all were talking about, criminal protective order. And then when we hear a lot, when people call in, they ask for a restraining order. Does anyone know what a restraining order is, or does Utah have them?
That's the one given at the time of the divorce, or a divorce. Judge can issue that one.
Oh, do you mean the injunction, the domestic relations injunction?
Well, I've heard about the restraining order, which is, most people will ask for that one.
Mm-hmm.
But then, I know that's at the time of the divorce, they can get the restraining order, so I don't know what the difference is.
Yeah, so a restraining order is really an order that you can get in any type of case, any civil case. So it could be like a property case where somebody's digging a hole in their yard, but it's like, you believe it's coming into your yard. And so you request a restraining order in a property case, asking them to stop digging until it's decided whose property that is. But it could also be in a divorce or custody case if, say, one of the parties is ordered sole physical and sole legal custody, and the other parent picks the kids up and takes them out of state. You could file a temporary restraining order in the divorce or custody case to try and get the kids back. So it's basically an injunction to stop somebody from doing something, but it has to be filed in a case that already exists.
I have a question.
Yeah.
On, the civil stalking. Can we do a stalking injunction on? I don't know how to word it. So obviously without mentioning names,
Mhm.
I do have a case where I'm meeting with the parents next week. They have a 15-year-old girl. And we're trying to see what would be the best way to go against a 17-year-old boy. So would we be able to do a stalking even though she's under 18? Or would a child protective order work
Yes.
best?
That's a good question. Do you know? I have some other associate here from Utah Legal Services.
Related or not related?
So I guess I don't know how much I can go into the case about it, but they had consensual sex. She was 14 at the time. He's 17. So I mean, he's still under the age, but she turned 15 after this
Event.
He's been stalking her, following her, going to her house, going to places where she's been, and he's been told not to.
Yeah, I don't know off the top of my head if the age limit applies to a civil stalking injunction the same way it does to a cohabitant abuse protective order. but my guess is you would need to file a child protective order.
It does.
It does.
Yes.
Thank you.
They've had consensual effects.
Even if she's underage.
Alicia Fisher from Davis County said our court would tell us to do a child protective order for both signers.
Yeah, I think a child protective order is the best route. And the juvenile court could direct you to file a different type if they feel it's appropriate, but I think that's where I would start.
Okay.
But great question. I love the questions, so please ask more if you have them. Yeah,
It's like this, I don't know if I'm using the correct terms, but like the standard of proof for like a civil stalking versus a criminal, or, you know, what's the difference there?
yeah, great question. So for protective orders, the burden of proof is just a preponderance of the evidence. So it's just more likely than not, the events occurred or the domestic violence occurred.
And is it the judge that will determine that? Like to find it or like, you know?
Yeah, so the judge initially who signs the temporary protective order, is basically just looking for, is there enough evidence that I feel like this could be granted, basically. It's a much lower burden at that point, and it's not until the hearing, either in front of the commissioner or the judge, depending on what area you're in, that then that burden of proof really applies.
Thank you.
Yeah, but the criminal burden of proof is. What is it? Yeah, beyond a reasonable doubt. I should know that, but I do not practice criminal law.
We had another chat in the comments. Lonnie Stone from Utah County Legal Clinic said child protective order can go until age 18 if it's not with the parent. I have had an underage rape victim
Sorry, guys, we lost him for a second.
Why?
That's not really.
Okay.
Is it working? Okay, everyone come back and sit down, please.
Okay, now you won't have the bar either.
Oh, awesome, thank you. Yes.
When someone asks a question, we usually speak for questions.
Oh, yeah,
That you're answering, because sometimes we don't hear the questions.
Yeah.
So we're not keep.
yes, thank you for letting me know.
Oh, I can tell you what it was.
Okay. So going back to this, the criminal provisions of a protective order versus the civil.
All I can do then is have that yours kids sitting here and I. We got now, you know, what, let him walk up to a certain point.
So the criminal provisions of a protective order can be enforced through law enforcement. Whereas the civil provisions are enforced only through the courts. The criminal provisions carry criminal repercussions, including arrest and criminal charges. Where the civil provisions only carry civil repercussions like fines, attorney fees, and potentially time in jail if the judge orders that. The criminal parts stay in place for 3 years, and as someone already mentioned, the civil protections only stay in place for 150 days after the entry of the permanent protective order. So some examples of the criminal provisions are like the no abuse or domestic violence should occur, no contact, no or stay away order, and then property orders like who gets temporary possession of the house or the car. Whereas the civil provisions are things like not to interfere with the phone or the utilities in the house or of the petitioner. Not harming pets, the custody and parent time orders, not traveling out of state with the children, and not using illegal drugs or alcohol during parent time with the children. So all of these civil provisions only last 150 days from the entry of the permanent protective order. And so a lot of people, in fact, I just had a case recently where somebody is going to trial in their custody case. And never got temporary orders because they told me 2 days ago that they have a protective order in place that has a custody order in it. But that protective order was granted almost 3 years ago. So they have not had any custody or parent time orders for the last 2.5 years and didn't even realize it. So that's, you know, that confusion can have big repercussions if the other party did realize it and tried to keep the children, then there would be no order in place. Oh. Okay. So. Like the previous slide shows, you can get a custody order through a protective order temporarily, or you can get a custody order through a petition for divorce or petition for custody. If there is domestic violence, generally, I would suggest somebody getting a initial custody arrangement through the protective order, and there are several reasons for this. One is.
You can keep going, sorry.
Okay. With a protective order. There we go. Thank you. With a protective order. Sorry, you're good. The hearing must be held within 21 days of filing the request for a protective order. So they get in front of a judge or commissioner a lot faster. With a petition for divorce or custody, if all you file is the petition, you might not actually see the judge until trial. Like my client who I mentioned a couple days, or that I met with a couple days ago, and has had a custody case lingering for 3 years. But if you do a motion for temporary orders in the petition for divorce or the petition for custody, you can get in much faster, but it's still gonna be a couple months before you actually get into court. So if there are concerns about the child, especially related to domestic violence or abuse, it's best to move quickly and get a custody arrangement through the protective order. With a protective order, you do have to prove that one parent was a victim of abuse or domestic violence, or that there's a substantial likelihood that that will occur. With a petition for divorce or custody, you don't have to prove that, and so, you know, there's no barrier to getting a custody order through that route. Another benefit to getting a custody order through a protective order is that if you request a guardian ad litem, it's granted and it's free. Do all of you know what a guardian ad litem is? Just in case anyone does not, it's the attorney for the children, and so they'll represent the best interest of the children and speak on behalf of their best interest. And so, like I said, with protective order, that's a free attorney that the children get. With a petition for divorce or custody, the parties have to make a motion for it, the judge has to approve it, and then they have to pay for it themselves. And that's just like paying for an additional attorney, which is very cost prohibitive. And then, like I said, once the custody order is entered in a protective order, it's valid for 150 days. In a divorce or custody case, the temporary order will be in place until the parties reach a final order, which then that final order is in place forever. So that's one benefit is if you get an order through the petition for divorce or custody, you don't have to go back to court again in a different case. But with a protective order, since it only lasts 150 days, you need to then file now a petition for divorce or a petition for custody to get more long-lasting orders that way. Any questions about that? Yeah.
I just want to clarify, so if somebody gets a protective order, they've got the 150 days, so then we might want to say, okay, if they haven't started with custody, or divorce proceedings, to hurry, get with an attorney and have them file a temporary petition for custody. And I assume that any attorney would probably hurry on that so that those 150 days aren't up, right?
Right, yeah. So, yeah, so the question was if a client comes to you and has a protective order in place, but it's only gonna last 150 days, we should encourage them to then get a more long-lasting order through a custody case or a divorce case. So if that happened, well, we deal with that a lot at Utah Legal Services. And so what we do in that scenario is if we can take their divorce or custody case as well as their protective order, then we will file the petition for divorce or petition for custody and file a motion for temporary orders at the same time, so that we can get into court quickly on the temporary orders, but then still have an ongoing case in the divorce or custody. Any other questions about that? And with that, since a motion for temporary orders, you'll usually get a hearing within about 2 months. It's still enough time to get an order in place before that 150 days expires. But you do need to act quickly to make sure the protective order doesn't expire before you can get into court. If that happens, you can do a motion to extend the civil provisions of the protective order in the protective order case. And so if you're kind of cutting it close, I would encourage the client to ask for an extension in the protective order. So, how custody is determined and the role of evidence. So the court looks at a lot of factors in determining custody. And House Bill 272 from this legislative session, or this year's legislative session, actually made a lot of changes in this area of law that are really beneficial to domestic violence survivors. And I think it's been a real help to our clients, and made some really good changes. So I'm sorry again about the formatting. I don't know why I did that.
I think it's because I opened it in Google Slides instead of PowerPoint. Sorry.
Oh, no, that's totally fine. I was just like.
I just realized.
I promise I did.
Yeah. I'm not this bad at it.
That was my bad.
No, you're totally fine. So at the same time that these changes came out, a lot of the domestic provisions of the Utah code were also changed. And I don't know how many of you work with the Utah code or have noticed that, but there's a lot of, especially I think people know the code when it comes to like the parent time arrangements, like 30-3-35, 35.1, 35.2, those are all the different parent time arrangements. And so we're all gonna have to learn new lingo for those parent time arrangements. But some of the biggest changes that came out of this is related to the factors the court has to consider in custody, in determining custody. And so first and foremost, in determining custody, the court shall consider the best interest of the child. That's always at the top of the list. And just like the framework for how you're looking at all the other factors. But then the court also made some, or I guess the legislature also made some big changes in that they now added 3 factors that the court shall consider, whereas a couple of these were included before, but they were included in the court may consider these things. So they made it mandatory for these things to now be considered. One is evidence of domestic violence, physical abuse, or sexual abuse involving the minor child, the parent, or a household member. So now that's kind of at the top of the list of the factors the court has to consider. And when you're talking to your clients about these things, you can help in gathering evidence that will support these different factors. So I made lists of things that could be used as evidence for the different factors. So evidence of that, I mean, you all work with victims or survivors to help them get protective orders, I assume. So it's very similar to the same evidence you're gathering for those. Whether the parent, so now the court also shall consider whether the parent has intentionally exposed the minor child to pornography or material harmful to minors. So that was also one they could consider or may consider, but now they have to consider it. And then the last one was added, I don't think it was even in the factors before, whether custody and parent time would endanger the minor child's health or physical or psychological safety. So things that can be used for both of those are things like DCFS reports from an investigation, any criminal charges of the other party, text messages, video evidence, or things like letters from a therapist or a teacher or medical records.
I have a question.
Yeah.
you have any cases, I know this is pretty, like, relatively new, these changes, have you had any cases where, like, false DPS reports were made by the abusive partner?
Yes, yeah.
And how does that show up in these factors with the court?
Generally, if. I'll repeat the question, sorry, just for everyone. If she was asking if the abusing party or, the other party files a false DCFS investigation against the party, how does the court consider that factor? Is that what you were asking? And so generally, if somebody files a false allegation, it's going to come back as unfounded or unsupported. And so generally, the court doesn't look much at any unsupported findings. They really are only looking for supported findings of abuse or domestic violence, or neglect or whatever the allegation is. So in a lot of our cases, there are lists of unsupported allegations and they just don't take those seriously.
Okay, but question about that, if the other parent consistently has those unsupported claims, will that impact them? Because doesn't it look like they're trying, you know?
Yeah, and that's definitely something we would bring up to the judge or commissioner, that this is just a form of harassment against the survivor, and they're just continuing to use the custody and parent time situation to further control
And
the
things like
survivor.
that happen a lot, and then if you do, does the judge give that a lot of weight in your experience?
Yeah, we do see that a lot. It's surprising. I actually had that on my last slide. But yeah, I think in general, both just anytime there's children involved, they're often custody and parent time, and the children in general are kind of used just as a further tool to control and manipulate the other party. And they'll fight for custody to the end just to keep some control. And so, yeah, if there's a protective order and then they continue to do that, it makes it pretty clear to the judge. If there's not a protective order, it can be harder to prove, but we still definitely bring that to the judge's attention. Yeah. Great question. Trying at 9:45. Yeah. Okay. So other factors now that the court may consider. So there's a whole list of them. And in this Utah Code 81-9-204, which was the old 30-3-10, it lists all of the custody factors that the court considers. And I would suggest all of you go and look at it, because it's very helpful to see all the things the court considers and how you can help the client find evidence of each of those.
I had a quick question, sorry.
Yeah.
The police report was not on one of your supporting evidence. I'm kind of assuming that might be helpful, but just wanted to ask that, because you say it's criminal charges, so is it helpful if we help them only get police reports where it resulted in criminal charges, or do we want to get any and all police reports where DV was reported?
Yes, a great question. So she was asking, I don't have police reports listed on here, but are those helpful? And the answer is, it depends. So we always ask every client that comes to us to try and get police reports, and it would be helpful for advocates to assist in that process, because we do appreciate having that evidence. At the same time, a lot of judges and commissioners do not allow police reports to be used in evidence because they're hearsay. Because it's basically the report of a third party. So unless we can get the police officer or somebody who wrote the report to actually come testify at the hearing or at trial, we just can't generally get those reports in. So it's helpful for us to have a better understanding of what's going on, or to find ways to use them. But for the most part, they just are difficult to use. Holly, are you gonna say
I was
something?
gonna say, I think it all helps also if they're certified, so it's an authenticated copy for their rules of ethics.
Yeah, yeah, so if it's a certified copy, that helps with the authenticity, but it doesn't necessarily help with the hearsay argument. Yeah,
Sorry. So then what's a helpful document if we're wanting to prepare a victim? Rather than a police report, like maybe like a charging document, like this person has charges and like something like that?
yeah, so we have access to Exchange where we can get the history of the case and stuff. And then we can also get like the information or indictment or affidavit of probable cause. Those things are all helpful. So if you have information like that that can be used or that you have access to, that's very helpful. Because that's just part of the public record, so it's not necessarily hearsay. Yes,
The only thing I was gonna say is, bear in mind, it may not be helpful if there isn't a conviction yet. If there is a conviction, we can ask the judge or commissioner to take judicial notice of that.
yeah.
But if it's still pending, it's not as helpful.
Yeah, what she was saying is pending charges aren't as helpful, but if there's a conviction or a guilty plea, even a plea in abeyance where they either pled guilty or pled no contest, that's still considered a conviction. So a no contest plea is still helpful.
Have you ever had a case where you had to request a new guardian ad litem? I had this interesting thing where we were supporting a survivor. And there was obviously like a custody case. And the guardian ad litem it seemed like, just from like a very objective perspective, a lot of people were saying, seemed like he was very biased towards the father. I know that a lot of people would be inclined to say that, but it was like, even in him saying things like, he was a lot easier to work with, he was a lot easier to get a hold of, and it seemed like was just making, like, it seemed like big claims of that didn't seem like were in the best interest of the children, but he just like really liked the dad a lot more, it was easier to work with.
Yeah,
So even though it seemed like there was a lot of evidence to say that there was harm happening on the fathers for the children, have you ever had a case where you said request a new guardian ad litem, or how does that process work?
yeah, in a protective order case, that's a lot more difficult because the guardians come from the office of the guardian ad litem and they're assigned to a specific case. So you would have to do a motion to remove or exchange, I don't know the right word, the guardian ad litem and give the reasons why, and you'd have to give really good reasons. And so it's difficult when that person's appointed to that position. In a divorce and custody case, usually the parties are choosing the guardian. And so it's easier to say this person's not working, but if that guardian is supporting the other party's probably not gonna agree to removing them anyway. So then you still might need to do a motion to do it. So it's not easy and there has to be good cause for asking for it. But that's a great question. Any other questions?
Make a comment with that.
Yeah,
You need to log in.
Remind
I need to
people,
log into.
like the judge or whoever, whoever they're talking to, they're not their enemy. A lot of times people are coming into it so guarded and almost defensive, and you have to remind them like, hey, they're here to help you, so just be respectful, dress nice when you go to court, things like that, and just, because like, the second they start arguing with the judge or whoever, it's not gonna help them. So anyways, in this part, same thing with the guardian ad litem, but.
yeah. Just for those who might not have heard, it's important to remind the survivor that the judge is trying to do what's best for everyone. They're not your enemy. They're here trying to help the situation. Same with the guardian ad litem. They may not say things that you like or you want to hear as the survivor, but they are truly trying to do what's best for the kids. And so a lot of times the goal of the guardian is to have both parents be involved in the children's lives in whatever way is safe for them. And a lot of times the survivor feels like, no, that other party should not have anything to do with the kids right now. But the guardian doesn't always see it that way. And just because the parties have issues doesn't mean the kid's in danger from the other party. So it's a difficult position they're put in. But some of the other factors, there's a lot of factors, and like I said, I'm gonna send this to you all. But one of the newest ones that also came from this House Bill 272 was a new factor of evidence of psychological maltreatment. And this is a brand new one. This wasn't in the custody factors at all before. And it's interesting, it's described as a repeated pattern or one extreme incident of caretaker behavior that intentionally thwarts a child's basic psychological needs, including physical and psychological safety, cognitive stimulation, and respect. It conveys that a child is worthless, defective, or expendable, and it may terrorize a child. So this is brand new. I haven't had the opportunity to use it much yet or to try and prove that factor just because it is new. And so I'm curious how it's going to play out in the courts, because you have to, it's an and, not an or. So you have to prove that all of those things exist. And so I think it's important because up until now, psychological or emotional abuse to the children has really not been factored in. It's really only been physical abuse, but psychological and emotional abuse has so much of an impact on a child, especially at young ages. Yeah.
Just out of curiosity, I'm wondering what kind of documentation they're going to require to realize that.
Yeah.
Especially if police reports are not necessarily the go-to documentation.
Yeah, great question. And so again, I haven't used it much yet, so I'm also curious what kind of documentation we'll be able to use. But I think a DCFS report, testimony from the child's therapist or teacher, or a report from the child's therapist or teacher saying these are the things they have talked about and this is the impact it has had on them, and the way they're feeling about it now. Medical records, similarly, like if the child's describing to their doctor what's going on. Yeah, so Holly, were you gonna say something else?
There was a recent appellate case, of course, I can't remember the name off the top of my head, but it talked about that very thing, and a lot of it was teachers, guardian ad litem, it was involved as well. The kids were of older age, so they were able to, verbalize it. And they were to the point of suicidal ideation, very afraid to go home, all of that type of stuff.
Great, yeah, thank you. Yeah, so I think therapist involvement can be really essential, but a lot of times it's hard to get it into court because of HIPAA requirement. So, yeah, it's a difficult thing, but it happens.
Teachers and school counselors are the biggest help probably there.
Yeah, teachers and school counselors help a lot. Any other questions on that? Some of the other things that came out of HB 272 were related to supervised parent time. It made some big changes to supervised parent time. So one is if the court finds evidence of abuse or domestic violence or an ongoing risk to a child and orders supervised parent time, the court should give preference of supervision by a facility or a trained professional. Whereas it used to be that the preference was given to an agreed upon third party, like a family member or something, that would agree to do it. Now the court is saying we should have a facility or a trained person being the preference, which I think is great if it's possible. The problem is it's expensive generally, and there aren't that many facilities that do it. So I'm curious with this new law, if more facilities will pop up because of the need. But a lot of times it's just too cost prohibitive. So, now the law also says if that is not available or affordable or practicable, like for instance, if the nearest one is 100 miles away, it's just not gonna work. Then they can use a mutually agreed upon third party, like a family member or somebody. But that person has to be able to protect the child from physical or emotional harm, and or abuse. So it didn't used to, the law didn't used to have anything in there saying what is required of the mutual third party. And so a lot of times the third party wasn't even supervising or wasn't really involved. And so there's a lot more requirements on the third party supervisor now. And then finally, it used to be that supervised parent time had to just be temporary, and there had to be steps for the person to get back to unsupervised parent time. Now, supervised parent time can continue indefinitely if it's necessary due to abuse or incapacity of the non-custodial parent to ensure the safety of the child. So there are exceptions now to make supervised parent time indefinite. So things you all can do to empower the survivor. So in advocating for custody and domestic violence cases, we should be trauma informed, focusing on empowering the survivor, creating a safe and inclusive environment, and minimizing further harm or not re-traumatizing the survivor as much as possible.
We have a question and, oh, I lost it. There it is. Can a non-custodial parent request these assessments if the custodial parent refuses?
Which type of assessment?
Camden, if you could, clarify which types of assessments?
Sorry, just on the last slide, you were talking about them being able to, if they can afford it, to have an assessment done to see if there's psychological trauma happening.
Oh, like a therapist assessment or something? Yeah, yes, either party can request it. And a lot of times the other party, the abusing party, will request it to say, yes, maybe me and my spouse had a bad relationship, but that doesn't mean it is affecting my child. My child still wants to see me. I still have a good relationship with them. And let the therapist decide if that's true or not. And reunification therapy is a good way to do that as well. Just leaving custody and parent time up to the therapist for the therapist to say, now you can start meeting in person without a supervisor. Now you can start having overnight visits. But again, that's an expensive process. And then one of the biggest things you all can do is focus on safety planning for custody and parent time arrangement, like who can help supervise if they're not going to use a facility, and help come up with ideas of who they feel comfortable with or who they might both agree on. Where and how should parent time exchanges take place? A lot of times survivors just don't want the parent time because they don't want to have to meet up with the other party to exchange the children. They don't want to have to see them. They don't want to have to be alone in a parking lot with them or something. So where are safe places that you can do that? A lot of times it happens at the police department or things like that. And just coming up with a plan to make sure they feel safe in that process. And then how can the parties safely communicate regarding the children? That's another big one is, they're gonna have to talk about the kids. So how best can they do that? There's a lot of programs like Our Family Wizard or things like that that allow communication, but then it's easy to monitor it and show it to the court if they're being inappropriate with their communication. Acknowledge the difficulty survivors may face, such as what we were talking about earlier, as using custody battles as a form of continued control or manipulation. And then discussing options like modifying or enforcing custody orders if circumstances change. Like if the abusive parent's behavior worsens after the entry of an order, they might need to modify the order, or they might need to enforce it and say, you're not doing what was happening or what was ordered. So I'm gonna take you back and enforce it to make sure it's better moving forward. And then the biggest thing is emphasize that the survivor has rights and options within the legal system, and they can seek legal help to ensure that their voice and concerns are heard. So just giving them all the options, all the information, but ultimately it's up to them. A client-centered approach. So does anyone have any final questions? Yeah.
Will you be handing these slides out?
I will,
We'll
yeah,
attach them to the drive.
Okay.
yeah.
It'll be in the handout and resource folder, so if you can use your phone, you can QR code it, and then we'll have it on the wheel.
I had a question, from like the legal custody and the physical.
Mhm.
If one parent has sole legal custody, is the other obligated to uphold the decisions, like taking them to the school that they've chosen, doctor? And they can't refuse that, and if they do refuse, what should our family do?
Yeah, great question. So she asked if one parent has sole legal custody, is the other person obligated to enforce that? So take them to the school that the other parent chose, or take them to swimming lessons or whatever it is. And the answer is yes, they are required to follow through with whatever decision has been made if they want their parent time. And if they're not doing that, then we need to file a motion to enforce the custody order. Yeah. So I have my information up here on the slides that will go out. Feel free to reach out to me if you have questions, or if you'd like more information. Yeah.
If a party is, if parenting time is supervised by a grandma or a family member, is that family member's report still available to everybody, or is it covered under HIPAA? I mean, if they're not a trained, medical personnel, if that's.
Yeah, great question. So if a family member is doing the supervision, they could be like subpoenaed to testify in court, or they could be asked to write something about how it's going or things like that. And that could be requested by either party. All right, well, my time is up, but yeah, sorry.
No, you're good. It was a good question. Thank you. We really do appreciate you, McKinley. Just so much great information. We will put the slides on there. We just didn't want to put them ahead of time because she had questions that she didn't want you guys to see before, things like that. So they will be added to the drive though, in PDF version, so you can have her contact information as well. So thank you so much. Just such great information. Okay. We are going to go to our next presenter. We're grabbing her. Carrie Ketchum is with Utah Dispute Resolution. So we'll transition to that. We are going to